soon as we get the mic on. Okay, I'd like to call the meeting to order. It's now 1:29.
Which paper to look at?
Get a roll call, Danny.
Don Colapetro. Vice Chairman Vincent.
Here.
Bob Mills.
Here.
Henry Bird.
Here.
Bob Thinis.
Here.
Rex Sims.
Here.
Fred Forbes.
Here.
Okay, what we'd like to do is start out by listening to staff talk about the meetings that we had, the last two meetings that we had regarding this topic, which is the regulations, operations regulations for the assisted living, the
Homeless shelter.
the homeless shelters, shelter workshops that were held August 16th and August 21st. They've got some things to present in terms of the other jurisdictions that they looked at and compared their regulations to the ones that we have come up to show you what that would look like as we begin to debate this. So I'd like to call John up, or first, I guess, would be
However you would like to handle it. If you would like to go through the comments from the previous meeting, we can start off with that, and then discuss other jurisdictions afterwards.
well, I think we'll start with the jurisdictions, perhaps. 'Cause it'll be rather lengthy to get into the other meetings first, so that everyone here can see that we've made some comparisons here. We spent some time looking back at other jurisdictions.
Is there a home?
We'll get Jackie Genson to present that for us.
Okay, good morning. Jacqueline Genson with Community Development. What I just provided to you a few minutes ago before we started the meeting is a memorandum dated with today's date. And what that was is at the last LPA workshop, there were a couple of jurisdictions that were mentioned in terms of examples of regulations that may be in place that we would want to look at, some examples of homeless shelter facilities or community residential homes that were done in certain jurisdictions. The city of Punta Gorda was referenced, the city of Tampa was referenced. Also, we were asked to look at the city of Naples as well. So this memorandum, there's a brief summary at the bottom, and then I went ahead and researched through their codes, contacted staff, talked to them over the phone, also through email, the best I could, and just asked, how do you classify homeless facilities in your jurisdictions? How are they permitted and whatnot? So it was a very general analysis, and that's what this summary will kind of go over and cites those regulations. I also have under each heading the source with a URL link. So if you'd like to, at your leisure after the meeting, you're more than welcome to search those codes as well. So first, you'll see Collier County, Florida. And it goes through how they define this type of facility. And what I found is that sometimes they referenced words differently. So in certain sections of the code, they would call it homelessness or homeless facilities. In other sections, they would call it a care unit. So, so under LDC 1.08.02 is a definition that the Collier County uses for a care unit, which is a residential treatment facility. And it does reference state statute, and it's 15 or more persons of care. So you'll see that definition. And they also have different categories. They have a category 1 and a category 2. And the biggest difference you will see is the number of persons for that type of category. And then the different types of services that they would provide. Under the next section, that's where you get into the zoning code, where I like to call it the meat. So in this instance, I looked at all the different conventional zoning districts in Collier County, and instead of, they don't have a table, they just list their uses. So under each category, such as C1, C2, C3, C4, C5, which is their commercial districts, and then their industrial district, they have uses approved by conditional use permit. And what that is, it's very similar to the city's special exception permit review process. So an applicant would fill out a conditional use application, put forth all their documentation, staff would review it in accordance with their land development code and growth management plan, and then the staff would render their decision. It would go before their Collier County Planning Commission, and then would go before the Board of County Commissioners. So it's very similar to our process here. It goes before two boards. Ultimately, City Council has its decision in our jurisdiction. Another mechanism that is available through Collier County would be the applicant could request that use through a planned unit development process, which is very similar here in the city to our plan development process. Of course, we get a little more specific with commercial plan developments, recreational plan developments, so there's different types of plan developments, but for the county, it's a PUD. Then you'll see under LDC 5.0500, the supplemental regulations, and that goes into the additional regulations that would regulate that use. So they go into the category 1 and 2 group care facilities again, and you will see they have referenced, for example, the minimum habitable floor area, minimum lot area for a person. They go into parking, and they go into separation requirements, special setbacks from different properties. So that was something that Collier County had. One of the unique factors that they did put in place, and this was actually after St. Matthew's House came through Collier County back in the 90s, is that when they created these regulations, they then made this type of use, if it did go before the commission, it had to be approved by a supermajority. So, and in our draft regulations, we are actually proposing the same thing, something very similar. There's also another reference in another part of the county's code of ordinances regarding the Human Rights Act, but I'm not legal interpretation, so I would defer to Audrey on that item, should you have any questions later on.
You want to talk about that now? Just
I haven't researched it, so I would need to look at it, but I believe the county right now, Lee County, is actually getting rid of its laws on that. So I would have to look very carefully what Lee County is doing before we added something in there.
Yeah, it's just a reference, but I really think for our purposes, we're interested in the zoning classifications of how Collier looks at these types of uses.
Do we have any questions?
Is that that's in Collier's?
Mhm.
Yeah, Collier may have a human rights ordinance, which the city of Benita Springs does not. When it comes to fair housing, I know that Lee County has an EEOC ordinance, which I know that they are right now in the midst of repealing. So I'd have to look at what Collier County's doing to see if it's relevant, and then see if there's applicable to Lee, if we want it or not. Remember, when you're dealing with counties, you might be dealing with other services than what cities normally apply to or normally have, except in large urban areas.
Jackie, do you mind if after each one of these references here that we could ask a few questions pertaining to
You're going
that?
to ask me as much as you can, and I'll answer to the best of my ability.
Okay.
Because these are not my codes.
Okay, rather than going through all of them and
Sure.
then ask questions. So if anyone has a question,
Do my
I have a
best.
question, if I may.
Let me take
Under the zoning district's permitted uses, no matter how it's done, there's still a development order required.
In Collier County, they have what's called a site development permit or plan. It's called SDP versus us. We call it development orders, but it's still, yes, they go through the same process where you lay out your infrastructure.
So a complete development order would be required in each one of these categories.
Of course. Although if there's an existing building and you were to have a change of use or change of occupancy, I mean, if the building was ready to occupy and all they needed was an occupancy permit, I mean, that's different as long as you met your zoning. And that's also assuming that when they got their conditional use permit, there weren't extra conditions.
I thought I understood it until I was left. In other words, in any of these zoning classifications here, in order to do this, there has to be a development order, except in the case of a building was all ready to go and all they needed to do was have an occupational.
If you're
change
dealing with a vacant piece of property or a piece of,
But that
or a
doesn't-
developed site
that
that
doesn't happen,
requires site
really.
improvements, then yes, you would need to file some type of site development permit.
But if you're changing the use from the original use of that property or building,
There's still a
you're
hearing.
still a hearing or a process that'll have to go through.
Right, this is assuming that the conditional use permit, or there's one in place that would allow such a use, and they met all the conditions of that permit.
One simple question. I don't believe you found any operating ordinance in Collier County, right?
That's correct. I just, I called and spoke to one of the planners, and we discussed the zoning code. I did search their code of ordinances for just a general homelessness, but it looks like, and this is in a lot of jurisdictions, they handle most of it through a special use permit or a conditional use permit. So then it comes before staff, the zoning board, and a commission or the council to put forth conditions to ensure compatibility or safe operations and whatnot.
So that's one of the biggest differences that we're seeing is that they're handling their situations, the homeless shelters, in a different way. They're not setting up separate operations per se, but they're trying to cover operations at a time when they're presenting SDP or development order.
Well, with zoning, again, you're more so dealing with compatibility, buffering, setbacks, whereas the operational permit is more of a county ordinance or city ordinance than a zoning issue.
And the one thing is that Collier County is doing what community development is now proposing that we would do, which is if somebody wanted to build something, it'd have to go through zoning and city council with a supermajority, even if they already had a site that was zoned and all that correctly. Is that right?
Yeah, the way our draft regulations are proposed right now, if, again, most areas in the city that are conventionally zoned is CF 1 and 3, I believe, that's allowed by right. Most of them have schools on them or the public library. So there aren't any conventional zoned properties that are vacant. But what we do have are some older planned developments and even some newer planned developments that have a social service group 3 use as a permitted use on the schedule of uses. But with our proposed draft language, if it's not specifically identified on the master concept plan, you have to come back to council. That is what staff is proposing.
And I think what John said at the last meeting was specifically identified as not only a homeless shelter, but so many beds. If you had homeless shelter, but you didn't have the bed count, it would still have to go through this process, I believe.
Right, and to our knowledge, there are not any
Right.
master concept plans that have that use specifically listed.
Yeah.
Typically, they do that for alcohol.
Okay.
Any other questions? Let's move on to the next one.
Okay. The next one was the City of Naples, and I researched their codes and also spoke to one of their planners. And as the public alluded to, and they're correct, the homeless shelters are not specifically defined in the zoning code. So if it was proposed, what this staff member was discussing with me, what the hypothetical process would be, since it's not identified in the code, is to file a zoning verification letter, which is what we have. Ask staff and their legal representative, how would you classify this use? And what would be their process for moving forward? What we also found in the city's zoning code is there was language, and they had this in almost every single conventional district category, that, and I'll read it for you. In the city's zoning code, an applicant may be able to request, now if it's not deemed a use variance, that's when the legal department gets involved, the use and the planning advisory board may, through a review and approval of a conditional use petition, which again is similar to our special exception process, and with approval of the city council, permit other uses which are similar to and no more intense than those enumerated in this section. So if you're in an intense commercial district and they want to argue that my use is very similar to other uses in the commercial district and it's compatible, I should be granted this approval. And that would be the argument that the applicant would have to make. They'd have to, during their presentation, present evidence to those boards showing that their use is compatible and is, you know, just as intense or very similar to those that are allowed in that section. So that is what we found in almost every single section. For commercial, they're very intense. They have a heavy commercial corridor district. They have an industrial district. So that would be a process that may be available to them. But if upon review, their legal representatives say that, you know what, staff, this is actually a use variance, you can't process this, the application would have to cease. And then the other way they could move forward is request a planned unit development. So request that specific use on the schedule of uses, create your development standards, goes before, you know, their local planning agency boards, looks like how the city of Naples does it, and then ultimately for city council.
In Naples, if we could start the questioning, the city council there has a chance to look at this as well if it goes beyond the staff review.
If it went through, again, these processes, there's two ways possibly, you know, that this could be processed in the city. You know, special use permit is very similar to our special exception permit, which goes to the local planning agency and then to council for review. PUD is the same thing. A PUD is a rezone of property, so it does have to go through a local planning agency review and then also to city council.
Okay.
Mr. Chairman, I have a question. Sure. As I understand your presentation here, then in the Naples zoning, there are no areas that are zoned by right for,
The use is not specifically defined.
pardon?
The use of a homeless shelter facility is not defined in the Naples zoning code. And the use has not been brought before them, so they're really not sure how that would be handled.
Okay.
So it's kind of like a wait and see. I mean, but a
Any other
PD process could be an option. So
Any other questions? All right, move on to
And I
Punta
just
Gorda.
want to point out, we do have use variances discussed in our land development code. They are prohibited, and I probably would say the same thing. And there is a big difference between a use variance and a special exception, and that's based on the standard of review.
all right, the other city that was referenced was the city of Punta Gorda, and went ahead and researched their codes, which is on their website. Chapter 26 is their zoning code. And this actually came about where someone had mentioned that they had approved a facility just for several people, and why can't the city do that? So I went ahead and called and spoke to a staff member there. This one's very interesting, actually. So it actually has a long history. It actually is county property, and it was designed as such and had an old special exception approval for assisted living. And then they had a private entity that was able to come in and provide homeless services. And the city originally denied the permit, and then it got into a Burt Harris claim, which is more up Audrey's alley. But the use actually was for a group home. So group homes, again, depending on certain codes, you know, this was for a facility of 17 people or less. So we're talking group home versus the actual homeless shelter. So then I asked the staff member, okay, well, how would you deal with this use? And just with talking with her, there is a definition in their zoning code called a healthcare facility, which could accommodate that use, which is allowed by right in certain districts. They did not have any supplemental regulations, but they might be looking at this again. On this property in particular, there was, with the Burt Harris claim, there was an agreement that the city was entering into back in August. But that is the summary on that item that was brought up last meeting.
What I'd like to understand is that when an applicant comes in, and they obviously have a homeless shelter that they're wanting to provide, they will, because of our definitions, it will send them to the correct category, meaning homeless shelter and not group homes.
Right, under our draft language, we are trying to make that distinction quite clear in terms of group homes, homeless shelter facility, so the numbers are rather clear.
I think that's important that we have them under the correct category here rather than searching around labeling it something else.
Right, and every jurisdiction is different in terms of numbers and how
Okay.
they break it out.
But the thing about that separates homeless shelters is the clientele. And I contend that if the clientele of a group home is the same as a homeless shelter definition, and I think Audrey did a real good job at defining what a homeless shelter is and what the clientele is.
Well,
I don't care if you have a group home of 16 or 7 to 16 or whatever, they should be called a homeless shelter. It's a small homeless shelter, but it's still for homeless people. And that's my own but we're getting ahead of ourselves, I think.
I have a question, sir.
Sure.
This operation in Punta Gorda that just recently was settled up, is that owned or managed by a religious group?
it was a nonprofit, and I think she told me the group was Castle. I don't know if it's
Pardon?
Castle. I don't know if it's spelled with a K or a C, but it was a nonprofit that was going to provide that service on that property. And it was interesting because it was city and county, and city and the county getting into a
I think what LPA member Sims is asking was, were there LUPA claims or RFRA
Yes.
claims that were also involved to complicate the suit?
It was because the building was built in such a way that there really wasn't any other use that could go into that building, and that's why they felt like they had a good argument for the Burt Harris claim. It's because you had different rooms, and then you had one communal facility area for them to eat and dine and whatnot. So what else could they use it for? So
The one in Punta Gorda, the maximum that they have there now under the settlement is 17 people?
in this
Or is that
specific
what's there now?
case, it was a facility for 17.
Okay. Is it permitted for 30 and only 17 there, or I don't exactly understand?
I'd have to look, but it was definitely a smaller facility.
Okay.
I think what Mr. Sims is asking, can they build another one in
Well,
Punta
that's what I
Gorda?
was saying is when I spoke to the planner, if looking at the zoning code, again, it's not specifically listed, but you could, like for us, when a use comes in, if it's not specifically listed in our code, we have the ability as staff to classify an under use that's most similar. So by doing that same process here, the planner said that, well, they would most likely probably fall under a healthcare facility. And then when you look at their code and you can see that healthcare facility is listed as a permitted use in several districts.
And we've got a lot more healthcare permitted locations in the city than we probably have.
Right. I mean, again, that's just what other jurisdictions
not a
do.
good
Ours are
solution.
different. We have totally different.
And just keep in mind, their definitions are different, their priorities are different. So when she says healthcare facility,
Oh, yeah.
it's not something that we're proposing or
Oh,
even
no.
can align up with.
Right.
And again, if an application did come forward, their planning staff and city attorney could have a different interpretation. Yeah. So.
Okay, let's move on to the next, Northport.
City of Northport, this, I actually reviewed the code and then left messages for the planners and also sent an email, and they responded back to me today. This is a very similar situation that you would find in the city of Naples. It's a use that's not specifically defined in their chapter. However, they do have this language in every single district, this generic language that does say an applicant can apply for and request a use not specifically permitted and not specifically prohibited in a specific zoning district through a special exception permit in accordance with their process and procedures for review and approval. However, they would have to demonstrate that the use applied for contributes to the intent of the zoning district as stated in the city's comprehensive plan and its unified land development code. So, again, that's a That's something that the applicant would have to demonstrate at time of the application and the hearing, that that use meets that criteria.
Excuse me, did you ask these folks whether or not they thought there was a need to specifically define homeless shelters?
No,
As we're doing?
I was just asking them, how does your city address homeless shelters within your jurisdiction and in your codes?
But they offered nothing up as to, that's not an issue?
City of Northport, again, I didn't talk to a staff member in person or on the phone, so we didn't have a in-depth conversation. I think Collier County, in my discussions with them, they changed their code after the first St. Matthew's house came in. And then their proposed expansion, nothing has been filed with the county yet, to
Okay.
the planner's knowledge.
Mr. Chairman, I have a
City of Naples, I think they're going to be curious to see what we do. City of Punta Gorda, we really didn't talk about that. City of Tampa, they have some pretty good definitions. They're actually looking into the soup kitchen issue, and they're going to be curious to what we do. So I will be sharing that language with them.
Goodness.
Mr. Chairman, I have a question. In the case of Northport, I see apparently that this can be approved by special exception only.
Well, it depends. That's if they meet that criteria, which
Okay.
is pretty.
But in any case, they would still require a development order.
Yeah. Well,
Their version of it, yes, sir. But that would, any type of construction project that alters a site's grading and handles water management and parking and all the infrastructure you would normally deal with under a development order would require to be permitted in any jurisdiction in Florida. They may have a different name for it, and there may be a different process for it.
Okay, but in the case of Northport, there is no permitted by right. It's not mentioned anyplace. Okay.
Okay, if we can move on to Tampa, if no one has any
right.
questions.
City of Tampa, they specifically do not have language regarding homeless facilities. But if one was to apply, they would have to meet the definition of what they call a professional residential facility, which is only permitted by an S2 permit, which is a special permit that goes through and ultimately is approved by City Council. So very similar to our special exception process. What I want to state really clear first is that the planner I spoke with said if a nonprofit wanted to provide housing, okay, for a homeless person, for up to 4 unrelated homeless persons, and they do not provide counseling on site, that use could be permitted by right. And that's more of like your community homes or whatnot. So just, so that was Tampa's, she wanted to tell me that.
Which we have here. I mean, we have
Right.
them here now.
Because they are provided some protections.
But the number of them would be unlimited, right? Possibly.
Can't, yeah, because
That
our
would be in
definition,
residential areas,
well, our
too.
definition of a family, you know, the definition of a single family, they
Right.
would meet that definition. LDC 27-545 is the definitions from the City of Tampa, and that goes into the different types of professional residential facility. Now, what she pointed out to me was if a homeless facility wanted to be permitted under this criteria, they had to meet this criteria. And it's pretty strict criteria if you look at it. So you got recovery home group A for a certain number of persons. So it's limited by 8. You got a group B, which is 9 to 16. Then you get into your residential treatment facility, which could be, you know, could accommodate a homeless shelter facility. But the important thing is that they have to be in some type of recovery care program. So they make that very clear. So if you're going to have a homeless shelter facility and you want to be permitted or reviewed under this criteria, they have to be given some type of recovery care program.
But here too, you list that it must be intensive diagnostic or therapeutic services,
Yeah. So,
which would require a pretty sizable investment in equipment.
correct. And then you have your life care retirement facilities, which it's almost kind of like your more elder care. The next section goes into special use permits in general. So I just cut out those excerpts for you. And these are what I would call your supplemental regulations, and they go into separation requirements of 2,000 feet. It does give council the authority to waive distances. Then they have some other separations from congregate living facilities. No external evidence that the use is operating as, that type of recovery facility. They have to meet, State Department of Health and Rehabilitative Service requirements. So again, it's pretty strict. And then it goes into, the site plan, so you can actually look at, what types of treatment are going to be provided, how will the security be provided. So that is all required at time of review of a special use permit through the city of Tampa. Also for their density, because I did ask them about their density, because it does state that the intensity has to be consistent with their comprehensive plan. And like us in the city of Bonita, our density equivalent is 4 beds equals 1 unit for this type of use. In the city of Tampa, they actually tie it to the persons per household ratio as a dwelling unit, so, which is a little bit tighter than ours. So that could be something that the city might want to look at, is tying it to persons per household. The next table, it's just a breakout of their conventional zoning districts, and you'll see under the professional residential facilities, the areas where there is nothing, that means it's prohibited, and where there's areas marked as S2, that's where that use could be requested through a special permit. And that's the city of Tampa.
Let me ask you a question back on the Tampa requirements. It says no external evidence of such use distinguishing it from a normal residential structure shall be visible from adjacent property, public or private. What do you think that would mean?
I would interpret that as, meeting your commercial design standards like any other property that comes in. Same signage requirements, no queuing outside, certain things being shielded if there's donation drop-offs. Those would be the kinds of things that I would think we would look for or require.
Could this also mean the size of the facility, the physical size?
I think in terms of a scaling and consistency of scale, yes, sir. In terms of an absolute number, I don't believe so. I think it's really just what is adjacent to it and what is that community developed.
Yeah, I asked the question because in adopting this, it's very subjective. External evidence, that's pretty vague.
And I don't know if that was intentional or
Yeah.
not.
Which is what we would try to keep out of what we're doing.
Yes, sir.
And again, this is something that they would present at time of hearing, so it probably gives, maybe the neighborhood and the city a greater level of comfort if they wanted to move forward with such a use.
Yeah, I would think in the ones that we adopt here that we would have enough of a description or definition that would allow the applicants who are considering this to review what's required before they submit reams of information and drawings and things like that, whereas that may not. I think here what we want to do is be able to identify this from day one when they come in, and it's not something other than homeless shelter. It's not being disguised via operation or, the character of it and anything like that.
Yes, sir. And I think that just generally depends upon the feelings of whatever jurisdiction you happen to be located. Some jurisdictions prefer it to be a little more vague because it gives them a broader authority. It also means they have to justify more to assert that authority. In this particular case, I would agree with you. I like having an ordinance for something that has raised this much attention so that everyone can read it, understand exactly what's expected, and understands exactly what the standards are.
Yes, and we do have something like that in place right now with our pre-application meetings.
Yes, sir.
Where staff can identify and walk through our requirements for any applicant.
Yes, sir.
Yeah, I think within the application itself, it's very specific that you must provide a narrative.
Right.
And there's where the opportunity is to find exactly what's happening.
And you also have a presentation of the facilities here
Right.
in a schematic form.
Yes, sir.
Okay.
Which comes back, I have a question.
If it's not too specific, I might be able to help. I think she's going to make some more
Okay, well,
copies for everyone.
I think she's
in the-
appeared. My question is, in all of these cities that you've talked to, got this information from, I believe I'm understanding that none of them have what's called an operating ordinance for homeless shelters,
That's correct.
which means that no matter what, if we have a good, strong operating operating ordinance for homeless shelters and make the definitions real good as to what a homeless shelter is, that we're way ahead of all these other communities.
I think it's just it's a different way of handling it because, I mean, some of the items that you want to address for these types of uses are very much zoning related. But you're correct. We do, in terms of some of the items that we are looking at in the operational plan, I mean, we're definitely a lot more detailed.
Oh, yeah, I mean, you never see that in any kind of zoning thing that I know
Mr. Chairman, I have a question. In your survey of these various cities, neighboring cities, here our concept is basically the client is going to be a single male,
of, not necessarily.
generally. Did you notice that in any of the others that they had different clientele basis of families, or was there any other mix? We're looking at a rather specific clientele, and I wondered if other people have a different makeup in their facilities.
I don't think I've seen anything that makes a distinction from a regulatory standpoint. I think maybe from an operator standpoint, you would have differences, but I don't know if you really want to have anything in your standards that would
No, I was
distinguish.
just,
And
when
reason-
she was contacting them, if their client was something other than a single male, which is essentially what we're looking at our clientele to be, potential clientele to be.
I can look into it some more, but my initial instinct's going to say that, you know, it's based on people, number of persons. But that's something I can definitely look in more if they handle, you know, women and children facilities and families different.
Well, the homeless shelter in Collier County, it's got both male and female.
That's correct, but there are also facilities along the West Coast that specialize in
Oh, yeah.
single teenage mothers. They're pregnant. Others are families. So from an operations standpoint, like I was saying, you obviously would design a facility differently based on who you wish to serve. I just don't know how much of that you could or should incorporate into a regulatory ordinance.
Well, then, you raised an interesting question there, John. For example, in Astoria, they have a home for pregnant teenagers, I believe. Our Mother's Home, I believe it's called, or something to that effect. If that was going to, if our church was going to start one in Medina Springs, it would come under these same regulations because it's a homeless shelter. It just happens to be pregnant teenage women.
The gender, age doesn't necessarily matter. It's going to be more the definition of the use.
And if I may, I'm a little bit familiar because our Mother's Home has spoken to my Rotary group. I believe they've spoken to everybody's Rotary group multiple times. I believe that is a community group home that is in a residential neighborhood where they have the mothers living with the child. It's the only place in Foster where you can have a mother and child living in the same unit, because otherwise they go to two separate foster homes.
I'm on the board. I was on the board of our Mother's Home. I'm not any longer. And they also have a requirement that by the time the mothers are 18, they have to leave.
Right.
Okay, my question is, but the definition, the restrictions the regulations we're drawing up here would also apply to an operation like our Mother's Home.
Yeah.
If they met the standards of what would be considered a shelter, yes, sir.
So my question, going back then to my original question, was other places have clientele uses that are other than just single male. In other words, it could be the same rules here would have to be observed by an operation like Our Mother's Home.
And remember that there is occupancy limitations, so if you had a small community group home, the Florida statutes do preempt that from any local regulations. I mean, as long as it's in a residential neighborhood. So, I mean, if you had something like Our Mother's Home,
6.
you would have that in a residential neighborhood, and I don't believe that's what we're trying to achieve here. We're trying to achieve where in non-residential areas, for other types of homes, not for community group homes.
And also in our proposed LDC4 language, we do break out women in abuse centers into a different category. So we can look at that as we go through the LDC4 amendments to make sure we're not, inadvertently making it more difficult for those types of uses.
I think what is interesting to me, and I want to compliment you on the research that you did here, is that it seems like that what we're pursuing here in the operations portion of this is a good thing because no one else is doing it. And I think by defining the operation of the facility, the public is assured that it's getting what it expects out of these new facilities. So I think that this research shows that we're out front on this.
And there's just one more jurisdiction that I have in there that wasn't a part of the memo, but was attached as some pages in the backup. It's Palm Beach County, and how they define that type of use is a homeless resource center. And I actually got this from one of our surveyor, who's also a planner, AICP, in our office. So I actually didn't talk to anyone, but he's pretty familiar with the codes over there. So they defined this as a homeless resource center in Palm Beach County. And just through the research that he did, they're very limited in the places that they can go into, and it's only done by an approval by the Board of County Commissioners for Palm Beach County. It's allowed, or it can be requested, in the PO zoning district, and as you go through the tables, you'll see it highlighted, and under almost every district, it's only permitted as an A, which is subject to Board of County Commissioners approval. So again, it's a very, I wouldn't say it would be a similar process. Here in the city, you have to get a special approval through the council to operate such a facility. But it's very limited in the places it could be requested for that use.
Can you talk with someone there?
No, this is one of the gentlemen in my office gave this to me. I haven't talked to anybody. He just gave it to me this morning and thought it was a pretty good resource too.
I wonder how that's working.
Well, before he started working with us, he was working in Palm Beach County. I don't know if he didn't indicate that any facilities had ever been permitted through this process.
Really?
And I need to point out that in Boca Raton, Delray, some of the communities there, I don't know about Palm Beach, I'm looking it up right now, there's been significant case law where there were violations of the Fair Housing Act with some of their ordinancing designs to try to deal with some of the issues.
So that concludes our summary. If there are some additional items you'd like for me to look into and I can bring back to next hearing, I'd be happy to do so. I will look at the women and children item for next time.
Any questions from the board?
Okay, thank you for your time.
Okay. Audrey, I would think that you would pursue some of those things because when this leaves our desk, it'll go to the council and they will have to know what's current.
Absolutely. There will be plenty of research. Right now, I'm trying to wait until we have a better idea of what the LPA will be recommending before I do significant research on some of the ideas that have come up. Seeing if you guys could first, channel it so I know what to research, because otherwise it's quite a very broad step. Once I have that better idea, I would do the research, we would refine the ordinance, bring it to city council, but again, remember, under the state statute, we would also have to bring it back to the LPA, no different than agriculture or anything else, for review for consistency with the comp plan.
So, John, you're going to now go through the summary of all of these 2 meetings that we've had.
Actually, just the first workshop, Mr. Chairman.
First workshop.
And what
okay.
we'll do is we'll go through the operations and maintenance ordinance. You should have in your packet a memorandum dated August 21st, revised September 5th, RE August 16th, 2012, workshop number 1. That memo captures the comments that were made during that workshop from the public. And what I would like to do with your permission is just go through start to finish of the operations and maintenance ordinance and discuss if any of these changes are something that you would like to see, or if there are additional changes that the LPA would like to include to any of these sections.
Okay, if we can get through that pretty quickly.
Well, we'll see. Starting off, page 1, item 1. ID checks. You will notice, now unfortunately the memo does not move along in the same page number that the ordinance does, so I will reference each of these sections. ID checks is the first item listed in the memo. And some of the suggestions included that we allow only Bonita Springs residents, legal citizens, identify other types of valid identification that can be used, require proof of legal immigration status, and legal immigrants admitted only. So there seems to be a pattern. Yes, sir.
In the first item under ID checks, it says Bonita Springs residents only. And Rex and I just had a conversation about that before the meeting started. Did they have to be a resident for what? A day, a week, 15 minutes? I raised the issue about the Bonita Springs residents only. And Rex and I had a conversation about that a little while ago. It had to do with something else, but does that mean 15 minutes? Does that mean an hour? Does that mean 2 days, a week, a month? What?
It was not specific. Now, this was one of the suggestions that had been presented by the public. If this is an item that you wish to include in some form or fashion, we can, but it does not mean that we, and if you did, I would recommend that you place
Something
some standard in
Is
there.
it a valid question?
Yes, sir, it is a valid question because there is not a standard answer that can be provided. That would have to be something created by this board, or at least agreed upon by this board.
Very good.
But there's been no discussion yet as to a time frame.
No, so that there has been a lot of discussion on providing any potential shelter space to meet the need of the city of Bonita Springs and not to be a magnet or regional provider. And I do understand those concerns. I would recommend that we do that through a bed count or through a population ratio as opposed to a residency requirement. And the reason for that is you know when you've reached a certain number of residents. If you're allowed 25 individuals and you have 25 individuals, it's very clear. But if you require residency, just like you said, how long do you have to be a resident? What forms of identification do you have to provide? What if you are a resident but you don't have those forms of identification? It brings up a lot of issues that I think you can avoid by looking at achieving the same goal in a different fashion.
I hear you.
Nothing. I was just saying, when we wrote the charter, we put a length of time in for the residents for a person to be a city councilman.
Yes, sir.
And it was contested, and a judge then determined that 6 months was adequate rather than 2 years. So I'm looking at this and saying, for us just to pull a number out of a hat, they have to live in do they have to live in a specific address for 2 years, or can they just live in the city 2 years? It becomes, as you say, unenforceable.
And I believe one of the most difficult sections of that to enforce would be the fact that we are dealing with those that are homeless. And if I do not have an address, then I do not have an address on a driver's license. So how do I show residency? Or how do I show that I wasn't a resident? And you can argue the merits of that, because I think there are good on both sides. But I think that you still get to the same goal by limiting bed count. And if you put a cap on the number of residents that you have based upon what you've perceived as the need, then I think you have met your standard, and where someone's address was does not seem to matter as much.
John, on the
Yes, sir.
on the other items under the ID check, I know when you presented it at our last meeting, a summary of it, on different ones you said, well, I don't recommend this. And so what about the rest of them? Which ones do you recommend? Which ones do you, so we know whether.
I would be fairly open with the types of identification accepted. In my mind, the purpose of an ID check is to establish and verify someone is who they say they are. And there are a number of ways to do that. And I think this goes to section further down in the ordinance that discusses tracking and updating databases and staying in contact with other agencies and departments. So in terms of what I would require, even what we have listed now with Social Security number or other form of valid identification, it's listed as and. I would list it as or.
Yeah, I've got a point on this. This is a zero tax generating revenue facility. I think that it's important that it serves legal residents of the United States of America.
And
Because if it isn't, that means that our taxpayers' dollars are going to go out to people that are not even United States citizens. That's why I think that proving status, now whether or not you want to say, well, you have, that does, I at least would like to know whether they're a legal resident or not. And then that can be in your reporting system.
Fred, have we identified that this shelter idea that we're talking about is going to be a tax-supported item?
Well, it will be. If something comes in that creates no revenue for the city, any kind of services that the city provides is going to go to something that's not paying any taxes. So the city is not going to make any money out of real estate taxes on this facility.
And what will come through this, because I think you are correct,
Yeah.
is when we discuss additional impacts that would be made to agencies, departments, or services that you normally don't see under a standard review.
But I, for one, would like to see my taxpayer dollars first go to people that are at least legal residents of the United States of America.
And I think that you have a very strong argument. My only question is, how do you show that? What is the standard to establish that? Because normally you would say, you or I are able to show it either through a passport, a driver's license, any other form of identification.
Well, won't they have a green, if they're legally here, even if they're homeless, wouldn't they have a green card or something? I mean, Audrey probably knows better than I on this.
Audrey, I guess you could address.
A legal card or a
Well, now,
purchase
You
something?
could
but
address the
once-
last two.
But once they present you a card, I would like to think that we're going to make sure that we go to the trouble to verify.
So you would want the shelter to do a E-Verify. Now, I know that E-Verify, for example, the city does E-Verify for when it contracts out for business to make sure it does
Yeah.
not hire people
Right.
who then hire as employees undocumented workers.
Yeah,
And that's tied in, and that's part of the federal system.
right.
I would have to check the rules of E-Verify because, as I recall, when you sign up for an E-Verify contract, you say you're going to use it for certain purposes. I'm not sure that occupancy at a homeless shelter would be the same as employment purposes. So I would want to make sure that that logical jump can be made. I can
Right.
tell you there are specific rules such as in education where you are prohibited from discriminating based on documented status. Because they want children to all get an education. Whether that's right or wrong, I'm
Right.
not trying to place a
Oh, no,
value
no, I
judgment. At this
understand.
point, that's what the law is.
Right.
So I would need to see if that would be something that's possible.
And to follow up on that, there is another section that requires job training. And so, and the ability to apply for employment from the facility. So at that point in time, legal status could be determined. Now, you're not talking about entry into a facility, you're talking about someone that's already there, but you would be verifying it at some point in the process. And those that are going into the facility are going to be required to be reported to not only a database that tracks the homeless, but also to the sheriff's department to look for outstanding warrants.
I think what we're saying is if the board chooses to have that requirement, then Audrey, you would be more specific and you could
Yeah.
verify
Yes, I would
that
do more
through.
research.
Oh, yeah.
And I believe we talked a little bit about the East Coast counties there, or
The East Coast counties have had some problems with the Fair Housing Act because of wanting to not allow certain type of housing. Most notably, not homeless shelters as we're envisioning them, but what they call sober houses or clean houses. They've been popping up on, I guess it's Ocean Boulevard, on one of, and people have been trying to, objecting to having that in residential neighborhoods. And there's been several court cases. Same thing in, I want to say Treasure Island, which is near St. Pete, has some case law also. And that's where you get the Fair Housing Act violations.
One of the things that I have seen in some of the instances we were reading about where they had legal challenges on them, one of the things I noticed that one of the churches had a homeless shelter for its members. And so then the question comes up, if one of the church members was not a citizen or was here illegally, would the city go after the church for that? I mean, that would be kind of a stretch. So when we get very specific about this, we kind of get out into left field a little bit.
You sure do. And one of the problems with churches and one of the concerns that you have is, again, RLUIPA, which is the Religious and Land Use Institutionalized Persons Act. It's easier just to say RLUIPA. And in that case, if the government can't adopt a zoning law as a land use function that substantially infringes upon a religious belief. Now, that gets to be very complicated. And the second part of that law is the fact that you cannot have secular, you can't allow a use as a secular use and not allow it the same type of use as a religious use. And that's the one I normally deal with. The substantial burden part, certain religions have certain concepts of charity. And in that case, depending on what they do, they may make an argument, and they might have a good argument, they might have a bad argument, depending on the facts, that, it furthers the religious belief by doing certain provisions for homeless. So that's where they would want it at their facility, and that's where you see what we call an RLUIPA claim. Whether or not it's actually viable or not, is another story. It goes both ways. And then there's the other issue, which is RLUIPA stands for the Institutionalized Persons Act. Well, that's normally jails, when we think of institutionalized persons. But some of what we're envisioning for homeless shelters may fall closely within that alignment. I mean, the way people are talking about this facility, I'm making that assumption.
Well, some of the conversations that we had, we were talking about a homeless facility, not a rehab, not a reconstruction, not anything, but just homeless.
Right.
And the other thing that in reference to Rex's comments here about the church that has a facility, and then they want to take someone who's not a citizen and have them in that facility, I'd back up a little bit and question whose money is being spent. Is the church collecting its own money and spending it? And if it's spending it on somebody that's not a citizen, I would believe that would be their business. If the if the city is funding that operation and you're taking people in that are non-citizens, then I think we would be rightfully involved.
And I think that's a valid point. I mean, you have some First Amendment issues. You have what we call overbreath. Overbreath is another constitutional doctrine that we're not supposed to be creating laws that capture not only who we intend, but other people that may have constitutional rights. And, you know, when I start hearing, you know, especially when you're talking about living, you know, people having a place to live at a facility, that's where you start going into that. And then the other one that's a biggie that I have to be on notice of is, I like these things on notice, due process. You know, are we giving people adequate procedural due process as well as substantive? Substantive I'm not really that worried about, but procedural I am.
Okay. Let's move on. That's only the first one.
Yes, that's
Yes,
only the first
well-
one.
That's my fear.
I need to clear something up, Sam.
I think for agreement on number one, we have the city attorney looking at the E-Verify process, and I don't know what you want to do, if you want to keep the language that's in there, or if you want any other modifications made.
Well, as I look at this for our benefit here, as you go through these items here, these topics, we are looking at these topics for the purpose of trying to identify which ones we want to adopt. So each of us need to be sure that you're looking at this from that viewpoint.
And I will be taking these changes back to incorporate in the document, and at your next LPA
Okay.
workshop, you will have a clean copy that shows these.
Okay.
I have another question. I got to frame it in my mind here. When we were talking about, does that get any better? When we were talking about homeless shelters, and we were talking about St. Matthew's House coming into Bonita Springs. Now, I'm under the impression St. Matthew's House is self-sustaining. If we're talking about a homeless shelter that's self-sustaining, I think some of these regulations are too restrictive. I think if we're talking about city-sponsored shelters, whatever, taxpayer money, then some of these restrictions do apply and should apply.
And if there are those regulations that you would like to make modifications to or clarifications to as we go along?
I think my area is gray to start with, and say if we're talking about a shelter in town, are the taxpayers' dollars going to be involved?
I do not know of any that have been proposed.
Wait a minute. When one of these homeless shelters comes to town, it will have an impact on this community. There's all kind of studies that show that it goes out 3 miles from the homeless shelter. You can have additional crime. You can have all kind of problems in your city. All of that costs the taxpayers money. That's what I was talking about.
I hear you. I understand. I agree.
Now, that doesn't mean that all shelters are going to create a problem. Many of the things that are in here, at least what I asked for, is to have a safety net for the community so that if it does cause a problem, there's some place to go. And so that, I mean, that's, and as John goes through this, there'll be some of those issues, I'm sure.
Well, I think in the handout that precedes this, I find plenty of places where there are lots of safety nets.
Yeah.
And there are discussions that have to take place between the operators and the city that will perhaps keep that under wraps.
Right.
Or that to a minimum. Okay, why don't we move on?
Okay, item 2. This is located on page 1 and 2. It's after the ID checks. Begins with the bullet point that states initial contact and intake forms and evaluations. Just to kind of go through real quick and outline what was in here, the way I'm envisioning this going forward is that the city would prepare a form for intake. That would simply be what you would call, for lack of a better word, an application. The city would not be involved in preparing any type of medical or mental health evaluation form. I am not a medical professional or a mental health professional. I do not want to be involved or associated with preparing their reporting. So if you're asking what uniform means and whose form, I see the city preparing the form for intake, but the operator would be providing the medical and mental health forms that would be reviewed and approved by the city. There was a lot of discussion on testing, and there was a couple of comments about cost and frequency. So I decided to do a little research just so this board knows exactly what we're talking about, and I found a pretty wide range. And if the low end, which basically means all the STD, HIV, tuberculosis, testing, the ranges I had, if you were to do this for every resident and do weekly drug tests, you would be looking at somewhere in the neighborhood on the low side of $66,000 a year, on the high side of $300,000 a year. So, you know, take with that what you will, but I know that people had raised it either as a point not to do it as often or as a reason to do it more often. If there is a requirement or a change in how we have the testing listed and what is done upon intake, please let me know. I've already stated that the intake form would be used to update the National Homeless Database and would be used in coordination with the Sheriff's Department to look for any outstanding warrants or history issues. I don't know if there's anything in here that really proposes significant change in what we have in front of you.
Now, the facility would pay for that.
I'm sorry?
The facility would pay for those screenings.
Yes, sir.
Mm-hmm. And that's $66,000 for 20 over a year period, which means that it happens on an irregular basis.
Yes, sir. If you're looking at testing every person as they come in the door at intake, they're there for a maximum of 30 days. You have, and I did this with 30 beds. I know that there's been discussion of reducing that, and the numbers could change based on it. But most of these, the STD tests, I found a range of between $50 and $200. For HIV tests were somewhere in the neighborhood of $45, and tuberculosis was between $41 and $362. I don't know why there's a difference. There just is.
So part of our request here to be included would have to also include how often some of the screening takes place. Otherwise, this amount of money is pretty expensive.
Do they have to, what kind of tests do they give them when you go to jail?
I'm looking that up right now.
Well, my question is, I'm beginning to,
Well,
I wonder here, Mr. Chairman, are we writing this to help people, or are we writing this to punish people? I think our definition here is getting clouded.
And I think there's been input on both sides, which I think only muddies the waters a little bit more.
Well, I look at this under 2D, for example, and I agree with it all. If they test positive, they can remain at the facility, but must enter a rehabilitation program. Yet in our definition over here that we got the other day, the homeless shelter is what we're discussing right now, and it does not include or have rehabilitation program as part of it in this definition. So I think we're kind of, it doesn't say a rehabilitation program in the facility. It just says one someplace. So I don't want to get those two related.
No, sir, and I think that what you look at is either having someone enter a facility or a recovery program that's at a different site, or they leave the site to go into a true recovery facility, one or the other.
But some of these things, for example, HIV, a person can have 20 years, 30 years. I mean, if they've already been screened, they already know how to take care of themselves. I'm presuming the responsible people, which I know that's a large leap for many people, you know, thinking that, you know, people can be responsible for this. You know, I mean, that person could have a normal life, and the bigger problem is and when I see the HIV issue, the confidentiality laws. I mean, if you violate those confidentiality laws, if you require like some kind of disclosure to the roommates or somebody else, I mean, that is a criminal penalty on the healthcare provider who or the social network, health network, who provides that information. I mean, because of the stigma attached to some of these illnesses.
I look at this intake and the examination of intake to protect the people that run the facility and protect the rest of the reasonable people that are in the facility. And a conversation starts jumping to medical care and rehabilitative business, which I don't think we want to deal with.
There's
What
no
do you think?
requirement that says you have to.
Mr. Chairman, the one thing that, and I agree with what Rex said about what do you have to do if you're going into jail, but you got to remember that these people that'll be in this homeless shelter will, in general, be out in your community during the daytime. So you don't want somebody with TB going into the local supermarket that you go to. I think there may be a little bit of an overdo in this, but even with HIV, you know, you can transmit that by a blood spatter. There's all kind of, so it would seem to me that those things should be known to the operators.
Well, but let me go into another example. TB has two different stages. You have active TB and you have non-active. I mean, again, similar to HIV status, a
Right.
person can have, and I can remember being in college, somebody in my dormitory having TB, but non-active. She was safe. Her doctors cleared her for living there. Of course, this was before HIPAA or anything else. It was in the 70s. So, I mean, she didn't have a problem telling people about it. But, you know, people have a fear of different infectious diseases to the point that they sometimes can behave irrational. I would suggest if you wanted to do anything in this ordinance, you would require the provider to coordinate with the county health department
That's
for what
fine.
screening is necessary,
Right.
and leave it at that.
And it could be too that we do this initially, but we don't require them to do it that often as once a month or once every 6 months. I
Well,
don't
I
know.
would not put a date in. I would require the
Right.
county health department to determine.
Once discovered. If they are being admitted and they go through a TB test, for example, and they found to have it, then you would report that to the health department, and then after that, then it would be up to the health department
Sure.
to
Right.
keep
And
up
I
with
would
that
think-
individual.
I think the health department would be, because of the concern of populations, the health department would be the ones who could actually tell the homeless provider what they should be providing, you know, what tests they should provide, whether there's a TB, measles. Measles can be I know with the migrant population, measles is a big problem in certain years. So, I mean, there'll be different times,
In
different
our
diseases.
requirements here, the simplest solution for us would be to just write in that the requirements will be met that are required by the state to be met, rather than write individual requirements for them,
Well,
because
at that point, you
should
don't
do
need to
that.
write anything in an ordinance.
After an
Yeah.
initial discovery or test is made.
I would then not write anything because that will happen, you know, but, I mean, I would just suggest if you want to write anything, just leaving it at coordination with the county health department.
it's like writing requirements for the kitchen, that's inspected by the state, so there's
A
no
lot of times
sense.
it's not. That was, that's another
A
discovery.
commercial kitchen is,
A commercial kitchen, but a lot of kitchens are exempt that,
I see.
that can fall
well,
under.
okay, but if it was a commercial kitchen, which I assume this would be, then it would be inspected by the state, so there's no need for us to write any requirement about the kitchen,
Correct.
except that it will meet the state requirements, whatever they may be, and
But
let it go at that,
is-
because they change over time.
Is this considered a commercial kitchen?
Well, that's the only reason I think I would leave it in there is because we do require that that's how it will be
Right.
interpreted.
Right.
Other than that, Mr. Sims is exactly right. There's no reason to have it in there.
Okay, let's move on.
All right, the only change I would look to make in item 2, I think that item E, 2E, should be deleted because we already have forms on intake or information on intake, but leave the rest of this section the same. Unless there is objection.
In where are you now? In 2?
Item 2E,
Yeah.
forms should be uniform throughout all homeless shelters. The forms will be prepared by the city, so they will, in essence, have to be uniform.
Right. Back up at D there, there was a statement followed by daily breathalyzer test. Would that mean random?
I think that this, the way it's written, requires everyone every day. Now, there is better financial news with breathalyzers because the top-of-the-line model that I found runs approximately $400, and then you can get 100 mouthpieces for $80. So
Would this be upon re-entry?
Yeah, I'm
That's
saying
the
daily.
that's what the way it's written, it says when you leave, if you leave to go to a
Oh, when you
job
come
or
back
for a
in
job
the
interview,
afternoon.
and you come back,
I see.
that's
Okay.
when your
I
test.
understand the use of the word now.
Did you want to leave the language as is, or okay?
As is.
Okay. Any other corrections, questions on item 2? Okay. Item 3. You will find information on this in the memo on page 3 and 4. It begins at the very bottom of page 3, the underlined section that says topic number 3, facility characteristics. And this begins to deal with the ratio of staff and minimum employees. Right off the bat, let me also suggest that item C, so item 3C, is unnecessary simply because, no, I'm sorry, item 3A is unnecessary because you have 3C. If you're requiring a minimum ratio of 1 to 20, and it was also suggested 1 to 15, and then you also have a standard that says you have a minimum of 2, and you're looking at a maximum
Yeah.
residency count of somewhere in the neighborhood of 20 to 30, it seems like there's a little redundancy. So unless there's objection to deleting item 3A,
I just have a question about the residence definition. That would include all people, whether they were men, women, or children, or infants. They all count as one.
yes, sir.
So you would suggest striking 1?
I would suggest striking item 3A.
Oh, 3? Okay.
There was some of the public had commented they wanted the security and social worker to be armed, social workers and medical staff to be available 24/7. They want disclosed the salaries of staff, require the staff to be bilingual, and also suggesting to remove item 3E. 3E states, staff shall be physically available at all times while on duty. I don't know why, I don't recommend striking that. I also don't necessarily support the other changes.
When you say available, do they have to be on-site available, or do they need to be on-call so they become available if the medical or social worker is needed 24/7?
It was to be, for the social workers, it was designed to be on call for outside of normal office hours.
On call, but physically during office hours.
They would be
During the night.
present, they'd be present during the day, and in the evenings and on weekends, they could be on
Right.
call.
Is there a standard to expectation of what on-call means? On-call, do you have to get there in an hour or 2 hours or 15 minutes?
We have that for
Physically
landlord
on
tenant
site.
stuff.
We can provide a standard. City attorney just informed me that we have similar language for landlord tenant
Right, with our rental permit, we require an agent to be at a certain location. I can pull that up. I haven't looked at it for a while and see what we require. I know they have like a certain amount of time before that to respond if there is a complaint in a residential neighborhood.
But we could also look at this, track it, because we have stipulations in here that require a meeting to occur between the facility and staff and others to, I guess, look at how the operation of the facility is going. And if that's the case, then a review of those records would then show any kind of deficiency, right? Rather than stipulating time like that. I mean, that's something we can also control is in those sessions that are to be held twice a year with the facility and the county staff and others. We're going to grow and learn about these facilities, and they will as well. So rather than burdening all these requirements here, such as with those requirements, we might want to wait until that time and let the reviews take place. That's only my suggestion. If the board has any comments.
I agree.
Yes,
So
sir.
I think that where we run across some of the things here that are seemingly want to have a time associated with them or a date, we might want to refer back to that one very good clause where in their meetings with us once every 6 months, we're going to cover topics like this. And we will require them to hold, the records, keep records of these kinds of incidents on the property.
Yes, sir. We can do that.
Mr. Chairman, I have a
Yes.
question.
Mhm.
Under 3F, is supervisory personnel shall be licensed in social work at what level? Is there a specification level there, or is it arbitrary, or what kind of license do they have to have?
This began as a suggestion from the public, and I will not claim to know all the degrees of licensure, if there are any, for social work.
First off,
So I think it's a very good question.
Are there licenses for them?
Yes, sir, they are.
Okay.
But
Now,
will
how
we-
many there are?
will we hold them to a state statute for social work and
Yes,
for medical? So that would be the statement, right?
But
Would that be state or would that be county?
that would be state. But I still think it's a very valid question because are there different types of licensing for social work? And I would, if you'd allow me to, I'd like to bring that back to you and do some
Yes,
research on that.
Okay.
Because we need to establish a criteria that someone has to meet. We need to be specific about it.
Are there any other questions or comments on item 3?
No.
Okay. Item 4 is the independent living plan. This is also on page 3. It is the second bullet point beneath medical treatment, labeled as independent living plan. Public comments included, why do we need to lock staff medication? Another comment states, remove certified nurse, should be a nurse practitioner or a registered nurse, someone who is authorized to dispense pursuant to state statute. And I would agree with that comment. And then the last comment was, should be done by a Florida state licensed social worker. I think where a social worker is required, a licensed social worker would apply. Once again, we'll go back to figure out what degrees of social worker there are. And also, I would recommend we make the change from certified nurse to nurse practitioner or registered nurse. Are there any other questions or comments? And
Let's move on to 5, please.
controlled substances, weapons, fire, and alcohol prohibition. This is on page 2 of your memo, and it is the second bullet down. There was discussion as to restricting the type or length of a knife blade, banning box cutters or straight razors, all pocket knives. I don't know if there's really any interest in looking to limit pocket knives or not. I don't look at a pocket knife in and of itself as something that's all that dangerous, although I guess in the appropriate hands it very well could be.
What's your choice?
I would leave it as is.
Okay, I'm going to go back up to A.
Yes, sir.
And the second line, well, the first line, use of controlled substances should be considered gross misconduct, and homeless, not should, will be evicted.
What would you like to do?
Will.
with-
Instead
Will?
of should.
Just something to think about, and in this question is one that I've asked myself when I was struggling with certain portions of this ordinance. From not only the city's perspective, but from an operator's perspective, from an adjacent resident's perspective, when you look at who comes in, who goes out, and how they function, is it better for someone to be removed from a facility and told to go their way, or is it better to have them within the facility where they may be a distraction, they may be obstructive, but they are in a more structured environment? And in certain cases, I've fallen in both directions. So for this type of situation, if you have someone that is been shown to be gross misconduct, is it better to have them within the facility or outside of the facility?
Good point, John.
Well, in the operations of the facility, though,
We're
the,
not a correctional facility.
no,
Or we're
but
not thinking about being a correctional.
no, not, that's right. And I think in the operations and part of these regulations, we would request that the operations would be deferred to the owner, that he would have a plan in effect that would take care of an unruly person on controlled substance.
Mm-hmm. And I think depending upon the operator and with their theories of how to operate that shelter, I believe that some operators would immediately remove an individual, and there are other facilities that would take the exact opposite perspective and try to handle the situation within the facility. And I don't know if there is a better option.
I don't know, but I find it's interesting that it has been reported that several shelters look the other way when it comes to liquor and drugs. I don't know where that came from, but certainly somebody had some substance to put that in there.
That was that language can be useful in terms of understanding the context, but I would recommend it's removed for the ordinance itself.
Yes, I agree
In
with
the
that.
school system, there are several items that are zero tolerance, so weapons and so forth, and I could see a similar situation here. But I agree with you. I'm not sure that use of a substance would necessarily be mandatory eviction, because perhaps we need to have that person under closer supervision. So but I think it should be an option of the operator. So should, in my mind, gives the operator the option to either do it or not.
In their
But
best
in the case of any kind of violence against another client or against any of the staff, then that should be a mandatory.
If there is violence against a member of the staff or other residents, I would expect them to call the sheriff's department and have them.
That is something, some of the
We
things
haven't
that,
addressed that any place yet.
Well, that gets into more of a legal issue, and it really doesn't matter where you're living. If we're roommates or if we're in a homeless shelter and we get in a fight and I punch you, it's just as illegal if we're homeless as if we have an apartment.
Right. And I want to point out the state statute on school systems, and that includes whether it's within 1,000 feet of a school, bus stops. There's different degrees of felonies depending on where they're located. Includes your traditional weapons, but also includes razor blade, box cutter, or common pocket knife, which I would tend to think would fall within the knives over 3.5. And you're just talking about having them being stored by the shelter,
Right.
so they can't be in the physical presence. Now, I presume no straight razors. They, not safety razors. The other razors.
Straight razor.
straight razor.
No, the ones that are allowed. The
Yeah, that's
plastic
safe.
stuff.
Oh, I see, razor blades and,
Well, in the
cons-
next element down, in the management plan, it talks about crime control on site and so forth, so I'm assuming that those regulations would be included in the management plan about what level of tolerance they're going to have against clients that are not abiding by the rules.
And it wouldn't just be their level of tolerance, but it would also be how they were going to coordinate and handle residents that exceeded their level of tolerance.
I'd like to make one point on what, I agree that the automatic eviction may not be what you want to do, but the other thing we do want to do, my interest in this is primarily protecting the public in the community. So if we have someone that's acting up, if they're not evicted, and that may not be the best option, they should be restricted to staying on site for some period of time or something, because once they leave the site, this stuff that they're doing is out in the community,
Well,
which could impact a
And-
resident.
And I would agree with you from a law and order standpoint. You keep the peace easier if you keep the problems away from the public.
That's right.
The difficulty comes in the fact that I forget who just said it, you're not running a prison facility or detention facility. How do you keep somebody somewhere where they don't want to be?
Well, that's going to get into one of the things that I feel real strong about. The operator of that facility has got to be responsible for the conduct of his residents, his or her residents in our community. Because if they're not, then that insurance policy that we're requiring isn't worth the paper it's printed on, because it only covers anything that happens on the site of the homeless shelter. And I'm interested in providing a source of protection for the community.
well, that comes into play when we talk about a management plan.
Yeah.
I think that,
Before we get that for us,
Yeah.
I opened the conversation about this 5A, should or will. And the conversation now is going toward the direction that should be left in and will should not be put in.
that's right.
What do you think?
I think that the current language is probably the better way to go.
Yeah.
Bob?
Yeah, and I'm just going to throw this out. I'm thinking about adding a word to in front of use. What about unauthorized? Would that make any
Unauthorized use.
difference at all?
Unauthorized.
Where is
Um,
that?
Not leave it out, because I don't want to make anything wordy.
If you,
I'm just throwing it out. You don't have to make a decision now.
I don't, if you're looking for a situation where you want someone accused of this type of misconduct to immediately be taken out of the facility, then I think you do need to put that in there, because I think that qualifies that type of behavior. If you want the operator to have the option as to who stays and who goes, I don't know if you do.
Would the nurse
just
be
my thought.
handling controlled substances?
Yes, sir.
Well, then you wouldn't want to have them thrown out because the nurse provided some
Yeah,
controlled
some-
substances. So it would be,
Unauthorized, or it was,
it was,
Yeah, I mean, if he's being treated
yeah, but your word there probably applies.
unauthorized, I think,
Unauthorized.
makes it very specific.
Let's just say unauthorized. I agree to
Yeah.
that.
The comments have been made, if someone is considered gross misconduct, should be evicted. And then other comments were said, well, should they be on the streets or should they be maintained in that environment? But if someone is committed an act that wants to get them evicted, shouldn't it become a ward of the sheriff's office?
if what they've done is criminal, then yes, I would imagine the sheriff's department would be more than happy to pick them up.
I mean, that answers the question of taking somebody who's totally unruly and you're worried about him being in the neighborhood, they go into the custody of the sheriff.
But that would not, I don't know if that would, in this particular case, we're talking about controlled substances, but if you're looking at the overall gross misconduct, and someone gets upset and begins to throw chairs, yell and scream, in that particular instance, you know, if they're not committing a crime, I don't know if the sheriff's department will come pick them up, but if they are,
Again, that'll fall under our review of their rules of conduct.
Yes, sir.
And for all the residents there. And you have to allow the operator some leeway as to decide what's criminal and what is not.
Yeah.
So I think as we review what they're going to submit to us in their narrative descriptions, we can break that down even further and help them define what we're looking for.
I would agree with that. Are there any more questions on number 5?
Well, you had in C, are we going to leave all knives with blades over 3.5 inches in?
I think that's just as dangerous as a 5-inch.
I think we gotta take them out.
Did you want to limit it to 1.5 inches, or do you want to take it out entirely?
I'd take it out.
I would say take them out.
No weapons permitted.
I feel, yeah.
None,
Okay.
none.
Just that
If you're
part.
in this kind of facility, there's no reason
Yeah.
to carry a pocket.
No weapons permitted, and if you want to, you can define weapons. A
Well,
weapon could be anything.
Yeah, I mean, a screwdriver, some sticks on the ground, nails that somebody finds, I mean,
It'll be defined after the incident.
right.
Okay.
But yes, some weapons might be easier to classify than others. But I will remove the words that state over 3.5 inches. So the
Right.
sentence will then read, "All knives with blades must be surrendered to shelter personnel."
Well, I think all knives, because all knives should have blades.
Say that again?
All knives shall be surrendered, because all knives have a blade. I hope all knives have a blade.
Mutually exclusive. Okay.
Okay, let's move on.
Item 6.
I don't know what a knife
Management
with
security
blades.
plan. Management security plan is on pages 4, 5, and 6. It begins at the very bottom of page 4. The comments that I've seen, and you can take a look through, they are numerous, so I don't want to go through each one individually, but I'll be more than willing to talk about any of these that you may have questions on or want to discuss. But I think this is probably one of the more important sections of this ordinance, so
Yes. And after we go through this, John, I'd like to take a little 10-minute recess when we
Yes, sir.
say get through number 8.
number 8.
Yeah.
Now, the intent of this section is so that, one, if you're looking to open a facility in the city of Bonita Springs, you know what's expected to be provided. 2, from the city's perspective and adjacent residents' perspective, if somebody is proposing a facility within the city of Bonita Springs, you know what to expect. And there's the ability to comment on something specific and something that actually has meaning as opposed to just the concept of a shelter. The goal here is not to make this easy or difficult. The entire purpose is to be descriptive.
John?
Yes, sir.
I'd like maybe back up just a little. Looking at it's a B, right above right above sanitary conditions. There's a B in a small paragraph there. What does it mean?
Well, I kept this a little vague, and there's a reason for that. And I know that we had discussed being specific, but there are some areas or departments that could be impacted that may be created some point in the future, or that I can't anticipate right now, or we can't anticipate coming together. So what I'm looking for is the ability to distribute an application, an operation and management plan, to whatever agencies and departments may be affected. The reason being, right now, I only have the ability to officially take comments in for those items that the state has established for adequate public facilities, roads, water, sewer, schools, parks. It doesn't include law enforcement. It doesn't necessarily include fire and EMS. It doesn't include mental health. It doesn't include rehabilitation services. Those are services that may or may not be impacted by the existence of a shelter. But the only way to really understand that is if they were to take a look at the application, see what role the shelter is proposing that they play, and provide comments based upon that information. Without something like this within the regulations, I don't have the ability to ask them for their 2 cents.
Thank you.
Yes, sir. Okay. Item 7, sanitary conditions. This is, you need to go back to page 3.
Excuse me, John, you're jumping ahead now to 7. I had
Sorry.
made a comment earlier looking at item number 7 and 8. In item 7, we talk about a maintenance plan, and you're talking about a minimum of a 250-foot distance from the premises. You said radius, and I'm saying, would you say distance and say property line rather than premise? But because it depends on the size of the facility.
Oh, yes, sir.
You know, you could have 250 feet within the facility. The premise.
Is the 250 an adequate number, or is that too much, not enough?
Well, you know what we're looking for, I guess, here is that if the problem's being caused outside of their property here and it's detrimental to the community that they're near, then they should be responsible, the facility should be responsible for some cleanup.
Property line.
You know? So we want to have something in there that is larger than their property. And so I would say the distance, and so you 250 feet from the property corner to wherever.
From their
Yeah,
boundary
just
line.
property lines.
From the
Yeah,
property
boundary
line.
That's right. And in number 9, I thought that the last sentence, part of it should go up in number 3, and that deals with to ensure that management and our guests maintain the quiet, safety, and cleanliness of the premises and the vicinity would be up in the good neighbor plan, or is that something that's different?
It can go in either place. It really goes to, this really goes back to item B that we had just discussed. And so in either location,
So you
I
could
would be
leave it
happy.
where it is, and it would be applicable to both?
yes, sir.
Okay.
Mr. Chairman, we're still in 6, all right?
We're still in 6, right?
Okay. In item 4, we talk about the communication, and a kind of question comes up, who they're going to communicate with and who the responsibility of receiving that communication is going to be. A few years ago, we had a pool room up on Old 41, and we learned after they shut the thing down that the EMTs have been there 45 times in a year, and nobody knew that. And so I look at it and I think it is important that we know when there are emergency things, but there has to be somebody responsible for receiving that communication. Certainly doesn't want to be the LPA, but
Well, when the application comes through to our department, what's going to be done is it's going to be sent to, first of all, everyone that they've listed in their communication plan that they're planning to coordinate with. And then above and beyond that, it's going to go to whoever else we can see or can imagine would be impacted by this application.
You want to be careful also that you don't want to trigger, like say, after 10 calls to EMS, it'll come back to staff, or there'll be an automatic marker. Because what'll happen is people will be afraid to call EMS,
Sure.
and then you'll have something really bad happen, or somebody, or worse, the sheriff's office.
And, Mr. Chairman, I have another question on item 11. I simply need an explanation of what that requirement is.
This is not necessarily unique. It's really a description of what they want to do on the property. And that kind of goes into understanding how they're going to operate.
But they would have done that back before, in the beginning, in the application for the development order
Yes,
and
sir.
so forth.
And in that respect, it's duplicative, but in one respect, everything is in one place. And it's easier to have this type of information in one location when you've got to go back and look for something that was approved 10, 12 years ago,
Okay.
than to have it in multiple locations.
Well,
That was the
actually,
intent.
wouldn't that be covered in number 1 of 6? Is that a duplication? One says
Number one?
permitted, description of permitted and accessory
No.
use, the other is narrative description of nature and characteristics. It sounds similar.
All you need to do is add a listing and take out number 11.
We can do that.
Okay.
And the other question I have in that section is under B, down in the very last paragraph, as part of the review of the operational plan, and here we're triggering the added facilities that Fred has brought up several times. And my question is, when will that happen? Before or after the fact? Does it happen every 6 months, or does it happen as an issue arises?
I did not put in a specific time period because I think that could change based in the department or based upon the operator. The fire district may feel that as long as the size of the facility stays the same, there's no reason for them to discuss this again. Maybe, maybe not. The sheriff's department may feel differently because depending if the operator changes and a different philosophy is implied, they may be making more visits or may be making less visits. So requiring the agreement but not going into the specifics at least allows for each agency or department to make their own decision.
But wouldn't every year it would come up for renewal, the agreement? Because, let's take the sheriff's department. If that shelter is one that doesn't cause a lot of problems in the community, then the impact on the sheriff's department is fairly minimal. Same way with EMS. Most of the people that would ride in the EMS ambulances would be what's called no pay. So that is going to eventually come back to the taxpayers.
Well, I think you could be right, but I could also see situations where there hasn't been a change and they don't want to look at it again. So it may be that every agency or department wants to set up it on an annual basis, and that is within their authority as the language reads.
Yeah.
Or they may decide that they only want to take a look at it if there's a change or a pattern or a trend. And that's well within what
Right.
they can do.
Is it provided for that, like if the sheriff says, in order for me to renew with you because of the extra amount of work you're putting on me, that you guys are going to have to pay me some extra money? And if not, that means it's going to come out of the city budget.
We have not prohibited an agency or department from doing that.
Okay, good. You have not prohibited.
Yeah, John, it's quite,
In answer to my question, then it's going to be essentially after the fact, at the end of the year or something, in an annual review, then we will determine whether there have been extra efforts put on the sheriff's department or the EMT or whatever.
Well, the review would be done by each of those agencies or departments and not by the city. The city could look from a public works perspective or a community development perspective, but they wouldn't be looking to review sheriff's department data or fire district data.
Mr. Chairman.
Yes.
John, would you envision that a entity would wish to reimburse extra charges incurred by the sheriff's department?
I don't know. I guess it would depend on how they were persuaded.
Well, and that gets into, because that's a general service, I'm not sure you can.
I'm not sure
start-
how it would function, but go ahead.
Yeah, I mean, we do that already for certain types of extra requirements such as alarms, if you have false alarms. So we do have some times where we will, but that's where a state statute came up and said, sheriffs, you can require this, so you can go to your cities and counties and get this laws. I'm not sure per se that you can start charging one property owner an assessment or a millage for additional services unless it's authorized.
John started my thinking on this because he said that some entities might want to
I understand.
not being forced, but want
They
to
may want
contribute.
it, but, and sometimes the problem, and that goes anytime creation of any fee, the same issue is you need to look at whether or not, is it really creating that cost? Is it that cost to the agency? Because certain fees, well, all fees have to be set up so that it proportionately relates to the services provided. So we can't really have a I'm scared fee and set up a special price.
If
you
you're
couldn't.
talking about, when you're talking about some of these agreements, the thought would be if I need transportation facilities for residents of my facility for mental health, because I know that there is not the mental health facilities located within Bonita Springs that they need. Whoever I work with on those transportation agreements may or may not ask for compensation, and I simply work in community development, so I can't tell you under what arrangements they may or may not be able to ask for additional fees. We have not prohibited that, but we have not encouraged it. It is the
If
role
it's
of-
an illegal exaction, it'll be an illegal exaction, and we won't do it.
But we can look at law enforcement, Lee-Trans, and Public Works, and the fire department, right? In other words, we can address those issues. If there's an excessive use of those facilities, we can address that, right?
We can address it, but I don't know if you can automatically charge a fee for excessive use of what's considered a general service. But that's something that, and again, I'll give an example. Lee-Trans works under they work with the Transportation Disadvantaged Commission, and they receive federal funding, and they have very specific requirements of what they're allowed to do and not do. So, I mean, there's a lot of research whether or not it would be permissible or not.
And I think it would have to be for a specific arrangement. I think Audrey's right. Well, I'm not going to obviously disagree with her on legal aspects, but unless you're contracting for a specific service,
Yeah.
Lee-Trans
Well,
can't offer you.
My concern is what Fred says, is that we get an excessive use by the sheriff's department and our fire department, and now it's going back to fire department or police want to increase their fees to the city because we're having problems with this one or several of them, whatever it might be. Can we have something trigger that conversation?
Well, you do.
And you would in an operational as opposed to a land use ordinance, you could create triggering excessive, but like I said, for false alarms, I know there is specific statutory authority to adopt ordinances to deal with that excessive fee cost. I'm not sure if you don't have that state statute saying you can create this fee, this fee, this fee, you're not creating a illegal tax under Spear v. Olson.
Right, but you see, if there's excessive calls to the sheriff's department, that then gets us into another area about the community that it's located in. If we're having that much trouble, there's going to be bigger problems than just a small one of excess fees. I think we're getting into how do we begin to control what is excess use or calls for this particular facility. The neighbors are going to be concerned about, this sort of thing. They're paying the fees, but they're not solving the problem.
And I think we start to get into that when we get to item 11.
Okay.
In terms of inspections.
Okay.
But yeah, it's not directly, but it is along those lines, and it does provide a process.
Well, to just make sure that everybody's clear on what I'm saying, if you take the good research that a number of people did in this community on the amount of police calls, sheriff calls in Collier County because of St. Matthew's House, not only at the facility, but the crimes that have been committed out in the community, any sheriff in his right mind would tell you it's going to take more law enforcement to keep the peace and tranquility we have now. Now, I don't want to be paying that bill as a taxpayer. I don't want my fellow taxpayers paying it. So somewhere we've got to devise something that addresses that, because that's the issue. I mean, that's really what a lot of the reason that the people have gotten up and made the public comments, and the city council at the last meeting that we had, that
Yeah.
I think it went on for an hour. or
Real
so.
concerned about that sort of thing.
But
and-
again,
and-
taxation, there's general services, and general services, you're not supposed to be necessarily charging a fee unless you can show that you have the right to charge that fee.
I mean,
That's where I'm urging caution. I'm
Yeah.
not saying you can't do it, I'm saying for each
Chairman,
specific
Les?
area, you need to exercise caution.
Rex, you?
Does this installation pays impact fees on the way in, doesn't it?
For the impact fees we have, which would be transportation, I don't believe they would pay would they pay Parks and Rec? Parks and
Good,
Rec?
yeah, it's residential.
And they, school, possibly?
Possibly. It's,
So it would be a sizable, because normally we don't set this up for, when a business comes to town, we don't make any particular,
Right.
because they pay the impact fees coming in,
Right.
which covers this sort of thing. So I find that, I think we're getting a little off the path here a little bit, because they're going to pay an impact fee going in, the same as any other business or installation.
They are, there is not an impact fee for the sheriff's department, there is an impact fee for fire and EMS.
And
Why don't we take a look at what's possible? And
Right.
at our next meeting, we can discuss this.
Do that, but I think my comment probably dealt more with if we're having a problem with this facility, how do we deal with that instead of fining them for things that they're doing? Right. You need to, they're going to solve a problem within X number of days, or they're going to be closed down. That sort of thing.
And really, that's what it comes down to. Are we talking excessive uses of
Right.
municipal and public services, or are we talking about a nuisance? And that's two different issues.
Exactly.
Yeah.
You can have somebody and I think the sheriff's office, the fire EMS, they would all say the same thing, which is you don't want to tell people you can only use the services 5 times, because what happens if you have that murder, but they don't want to make that phone call, because they don't want to get over that level. And so that just creates bad public policy. But what you can do is have, as you pointed out, very strong nuisance. So they will be creating a nuisance once they reach certain trigger points.
Right. In some of these facilities, you'll have corporations that would rather pay a fine than be shut down.
The other problem.
You know.
People have more money than sense.
Yeah.
Okay. Let's move on then to sanitary conditions and shelter size and occupancy. Then we'll take a break.
Okay. Sanitary conditions is on page 3, towards the bottom of the page. Comments from previous workshop was that the restrooms comply with the Florida Building Code and ADA guidelines. This goes back to what we said before. They're going to have to comply with those anyway, whether you state it in the ordinance or not.
Right.
Next comment was to add sanitary facilities are available only to residents, staff, volunteers, and authorized guests. You can do that if you'd like. I have no objection to that. And the last comment is shower facilities not open to casual passers-by and non-residents, which I think is very similar to the previous comment. So if you wanted, between comment 2 and comment 3, I'd probably recommend you include comment 2.
I was looking at
Add sanitary facilities are
7, under
available
7.
only to residents, staff, volunteers, and authorized guests.
I think the building code is plumbing code is going to supersede anything we do here.
Oh, yes, sir.
Yeah.
Oh, from an ADA and
Yeah.
oh, yes, sir.
Right.
Yeah.
So anything we write is going to be superseded by those agencies or those codes. Okay. Number 8. No question.
Shelter size and occupancy. This is on page 4. It's the first darkened bullet point. There's discussion as to the size of the facility. I think that the comments that when there's been a number given, the low end, as I think I've heard, is 22. 35 is probably the highest I've ever heard. We've proposed 30. However, this board feels comfortable. I think that based on our percentage, we had gone back and looked at the number of homeless within Lee County, and then took Lee County's population as a percentage, and then used that percentage to calculate how many could be in the city of Bonita Springs. The number was around, oh gosh, was this 20, 27, 20? I'll say 25, but plus or minus. We had used 30, not because I want larger facilities or smaller facilities, but because all facilities are going to have to be approved by the city council. Erring on the side of larger didn't necessarily bother me because it's not going to be built unless the city council says that it can be built. If you would like to reduce that number, I have no objection to that.
How did you come up to the 30 residents?
30 was close to the percentage number that we had come up with, but was a few beds higher. So, like I said, if you want to reduce this number, I think you're still consistent with the formula that we had come up with for calculating the potential number of homeless. If you want to keep it the same size, obviously we
But
propose
in
the same.
our, in our workshops, what was the predominant number?
25 tended to be the number that we heard the most.
15.
15 was mentioned.
15 to 20, I think.
Actually, it was 2 locations at maximum of 15 beds each. Integration versus concentration was the comment. But 15, you start talking
Heading
about
into
group
community
homes.
facilities,
Yeah. I like the idea of 20 to 25.
The larger you allow, the more you attract.
But then you can get an application for another 15 or 20, right? Or you could expand, well, you can't expand that facility, but you may. That'd be an option of the council to decide whether or not expanding one or allowing a competition and building another.
And that might be something, you might want to have a co-location requirement, similar to what we have on towers. That's why I use the word co-location. That prior to, upon this being, if this is too much, before any other location is being consider additional.
Expanding the
this one
additional.
location.
John,
I don't know.
the vast majority of the people that attended that workshop were of the opinion and thought that they were talking about, for the current population, one shelter of no more than 30. And that doesn't mean 30 and then next year somebody comes in and proposes another 30. It was 30 based on the current population. In other words, we'd have to get to 90,000 to build a second one. I would support, though, going to 25 if that, I want to make
If you
sure that
want-
it's
if you-
clear that it's one based on where we're at now, and you can't go and get another one till you double the population or something.
You know, I agree with that. I think the realization is, I mean, we're 45,000 people.
Right.
You know, and that, it probably makes sense at this time. And maybe another planning agency can decide something else, or council, but I agree with that comment. Any
What
other
we can
comments
do-
from the board on
Well, the
that?
only question I have is if the clientele over time would change to where it would be sheltering more families, and as John said a while ago, each live person counts as one, whether they be an infant or what the case may be, then I would be more inclined to go to the 30.
If you want, we can separate minor children from
Well,
the overall number
I
and
don't
leave it at
know.
25.
We're
Well,
just,
unless it's specifically stated, a person is a person is a person.
Mm-hmm.
If you specifically state that minor children, as a resident of a facility because their parent is there, are treated the following way, we can have them.
Under 18 or under, because minor, I worry about being 21, so
Well, we
under
could
18, under
specify.
12.
Why don't, why
Women and
don't,
children have to
how
be
about like
separated.
up to 3 or 4 years old, they don't count?
like at McDonald's, the kids eat free.
Well, yeah, there you
Well,
go.
That's a question. If more and more the clientele is going to be away from what we are visualizing now as a single male, and it's going to have more families involved, or women with children and so forth, then we could use up the 25 pretty quick. And for that reason, I would be more inclined to look at the 30 number as a maximum, and that would include all warm bodies, adults or children or infants.
Well, you also could look at separate facilities, meaning that if you've got, and you may end up doing that where you have 30 men in that facility, and something needs to be done for women and children.
Well,
Now,
once you
there's a
hit that maximum number, whether it be 25, 30, or whatever you choose, once you hit that number, you're done.
You're done.
Right.
That's right. You see, and so if we do have women and children that do come into Bonita, they have no place to stay, which is a worse condition. So it may be that if you begin to separate families, men, women, and children, from single men, there may be some opportunity there to look at the characteristics of that and decide what needs to be done.
No, I think we ought to have a cap
Yeah.
of some magic number. It doesn't say that as experience comes down the line in a couple, 3 years, and we see the clientele changing, that couldn't be changed. The city council would have the right to do that. But I think if we start out with an arbitrary figure that includes all warm bodies in there, and say this, when you get to 30, you're done.
Well, I agree that a cap is necessary. But what I'm thinking about is that when the cap is reached and you have these kinds of conflicts, you might not be able to wait until you reach the number you talked about, Fred, to approve another facility. Because it's a different characteristic. It's a different use.
Well, and what I think I can do for you is come back with a separate calculation that we might use or you might want to consider for children, and also define
Right.
children.
And families.
Right, there's a
families.
trigger in there that happens because of the characteristic of the facility.
Right.
That's the reason why when Jackie was making her presentation, I was interested if in any of the other surrounding cities, if their clientele base was different than what we have in our mind as what our clientele base is going to
And
be.
it was a good question, yes.
So my understanding is you want to make some sort of accommodation for families. And so when I bring something back to you, it will basically be a lesser calculation, so a child wouldn't be the same as a person
Yeah.
when you're coming up with
Let's
residents.
look at that, and if you do the math, as Fred had talked about, take and compare those and see how those situations might be approached, because it's possible that could happen.
Yes, sir.
If we're really looking to help people, then that is something that we need to address, John.
We can
Let's
do
take
that.
a 10-minute break, and we'll reconvene at 10 till.